So Kirsty, this week is Family Mediation Week. How would you best describe the mediation process?
The mediation process is basically one mediator assists a couple to resolve the issues they have arising from their separation, and the couple can choose when the meetings take place, the couple can choose when they happen. It's not dictated, it's a voluntary process, so both people have to agree to go to mediation, but the idea is it will save the couple significant time and cost, and most importantly enable them to have input into what is going to happen for their family going forward, rather than have a decision imposed on them by a judge that they might not be happy with.
So they control the process, or do you control the process as a mediator?
The mediator will control the discussions to a degree. They will make sure that both get a chance to say what they feel is best. They will make sure that both have input into what is proposed. They will ensure that there is a proper financial disclosure, for example. But in terms of the timings, rather than having a court date imposed on you and a timetable that might not fit in with your work requirements, with mediation, the couple decide when the meetings will take place. Sometimes, for example, it might be easiest to have a mediation over Zoom or Teams in a lunch hour, rather than having to attend court at 3:30 when you're also due to collect children from school, for example.
And how long would a mediation session last?
A session normally lasts between 1 and 2 hours, and you would expect with a mediation it will be clear after 3 or 4 sessions whether you're going to be able to resolve it through mediation or not. Now sometimes it may be that you go on to have further sessions because, for example, you've got a situation where you've agreed the arrangements for that year, but you decide it would be helpful to meet again in January to talk about the arrangements once the school holiday dates are published for the next year. So again, there's a lot of flexibility, but you would normally know fairly early on whether or not it's appropriate.
I've been told the traditional adversarial approach in the court process can take up to 1 or even possibly 2 years. How much quicker would the mediation process be?
A lot quicker. You would hope to resolve it within 3 to 6 months, and this sort of 3 to 6 would be if a case is more complicated. So if, for example, you need a pension report, you need accountancy evidence, but if you know what the finances are and you know what you both want, the mediator will assist you to get to a solution that seems to be within the bracket of what a court might do in the circumstances.
So you've talked about accountancy. Can you bring in other professionals to the mediation process, such as accountants or financial advisors?
Yes, you can have counsellors, you can have a financial expert to deal with valuing a business, you can have a pension expert, and all of those experts would be instructed jointly. So again, the couple have some input, and for example with a family business you may well find that there is a company accountant already involved, but it will give reassurance to the person who's less involved day to day to bring in someone else, and that person will then cross-check, look at it. And I've had a mediation recently where we've said we'll let the company accountant speak to the independent accountant, let them narrow the issues. Now that could also happen within a court process. It just takes a lot longer and is a lot more time consuming because you've got the solicitors going backwards and forwards, asking them to deal with things. All of that is incurring cost. You've got a lot of correspondence. Mediation can cut that out.
And presumably if you're in mediation to discuss children issues, we can involve professionals such as family therapists or counsellors.
Yes, and a lot of mediators, including myself, are qualified to see children as part of the mediation process, so we can have a session with the child, get from them what they want. Now sometimes they will say please share this with mum and dad, other times they will say I don't want you to share this bit, but it can help because quite often children will want to keep both parents happy. They'll say the same thing to both, or they'll just agree with what each parent says, and then when you talk to them they say actually what I would really like is this arrangement or that arrangement, or to be able to do this activity with this parent and that activity with another parent. So consulting with children as a mediator I find one of the most rewarding aspects of mediation, and I think very often they have some very sensible ideas. It's not about them making the decision, and that's made very clear to them. It's not up to them what's going to happen going forward, but it's presented to them as mum and dad want to hear what you feel, and they will take into account what you feel. They won't necessarily follow it, but it will be helpful for them to know.
And presumably one of the advantages for the clients is the fact that they and the children are in control of what the decisions are for the children, and not a stranger such as a judge.
Yes.
Or solicitors.
Yeah, absolutely. And they can, if it works for them to have children separated, for example, to do one activity at the weekend with a boy that's football mad and a girl wants to do something just with mum, they can do that. Whereas a court may well treat the children as more of a package and say all the children will be there every other weekend. So it definitely enables the family to have input and to really think about what all of their priorities are.
And it can be quite wide-ranging. It's not just contact with a child. Presumably if there's a dispute over child's name, which school a child goes to. That's something the mediator can help with as well.
Mediator can help with any issues in respect of children or finances, and there are some issues that are very difficult to mediate, for example relocation of a child, because that's a very black and white issue, and if parents can't agree whether a child should move to, for example, Australia with one or stay in England, it's not the same as when you're trying to compromise over how many nights a week the children are with each parent. But it still can be useful, and I have successfully mediated those issues, because if you can put in place arrangements for the parent that the child isn't going to be as near to, that they're comfortable with in terms of visiting and things, you can sometimes get around it. But those sorts of issues are much harder, because mediation is normally about a bit of compromise both sides. So if it's an issue that there isn't a compromise on, and that can sometimes be the same with choice of school, if both parents are adamant that a particular school is best, but again that's where speaking to the child, and sometimes even speaking to the school that they're already at and finding out what the teachers there think, can be really useful. And because it's done in a less acrimonious way, it's not about winning and losing, it's about working together, even where it's not the school that one parent wanted that is chosen. Sometimes it's easier to live with than having that decision imposed on you.
So far as financial matters are concerned, presumably a mediator can help with an overall financial settlement between married couples?
Yeah, so the mediator can assist to deal with capital, pensions, income, that's whether or not there will be maintenance paid by one to the other going forward. Also, if a marriage has been ended years ago, it may be that there is a maintenance order in place that can be varied up or down if circumstances have changed, such as a redundancy, or one person's cohabiting, or one person's got a job who didn't have a job before. It can also help non-married couples where they've got a property that they own jointly, and perhaps there is an issue as to how the equity in that property should be divided. There may be a declaration of trust, it may be something that wasn't considered at the time of purchase. So mediation is there to deal with all financial aspects arising from separation.
Are all mediators solicitors? Do they need to be family law solicitors?
Not all mediators are solicitors. There are some non-solicitor mediators, and sometimes people say that they prefer a therapeutic background, perhaps where children issues arise, and prefer a legal background where financial issues arise. But most mediators are qualified to deal with both and will happily do so. But it is fine to check with your mediator whether they feel that they should deal with all issues or whether they might refer you. And a lot of mediators will involve a family therapist if things are very difficult for the family and if the children are struggling. So there is the option to refer to professionals when needed.
Presumably a mediator who's also a solicitor would have an insight into how judges might think when asked to approve orders?
Yeah, they will certainly be able to give the benefit of their experience of going to court recently if they are. A lot of mediators do still practice as solicitors and have a mix of cases in court and out of court. And it is, as one who's in that position myself, I do find it useful being able to say to people, well, actually, when I was in court last week, the judge said X when it comes to university education, or Y when it comes to what's called non-matrimonial property. So it does definitely have benefits if you see how it's playing out in the courts day to day.
And the mediation process on average would take how long, did you say?
I'd say about 3 to 6 months for finances, and probably similar for children, assuming you can get all the information. Now, sometimes if you've got a particularly complicated pension and the information is delayed, then the pension expert will be delayed. But mediation itself will run at the speed that the couple want, and therefore will normally be quicker than waiting months for a hearing.
And would you say mediation process is appropriate for all cases, or are there cases where perhaps it isn't suitable?
We would always screen at the start of mediation to check, for example, that there's no issues of coercive control, domestic violence that will make it impossible. But having said that, there may be cases where once those issues are flagged, as long as the mediator can deal with them, which might be by having what we call shuttle mediation, where the couple aren't in the same room, they're in separate rooms, or for example, having a call that is by Zoom or Teams or WhatsApp video, and separate calls, where although it's still not ideal because there is a history of abuse, it's better than the court process, because with the court process they might see each other in the court building, they will have to go into the same courtroom potentially. Sometimes judges will put up screens where there has been domestic violence, but that can still feel a lot harder. So it's not going to be appropriate in every case, and if someone's not willing to disclose their position, then you're going to have to go to court to establish what the assets are. But in a lot of cases it can present an alternative to court that is more attractive.
And if one of the clients is being unreasonable, how do you resolve that?
As a mediator, because I also work as a lawyer, I would give them information that I feel, if the case was to go to court, that a judge would not be happy with what is being proposed, and even in some cases that even if they wanted to settle on that basis, there is a risk that the judge, when asked to approve a settlement, because a settlement is only binding if a judge approves it, and sometimes judges will look and say, I'm not comfortable with this settlement, it seems too geared towards one party and I need an explanation. So as a mediator that also works as a lawyer, that information can be given to the client.
And as a mediator, can you draw up the documents at the end that are sent to the court, or should the clients go to a solicitor too?
We normally get the solicitor to draw up, because one of the things with mediation is we do recommend that both parties have independent legal advice and that they have the chance to talk it through with someone who is representing them, and then that solicitor would draw up the order. So the mediator will do a summary of what's proposed, normally by email, or in a more complicated case it's called a memorandum of understanding, setting out the terms so that the solicitor can then talk it through with their client, check that they're comfortable, because with family law there is always a discretion and people have different views, and it may be someone looking at it will say, well, what about this, what about that, in which case they can come back to mediation and talk about anything that has been raised. But normally the solicitor is able just to draw up an order from the summary prepared by the mediator. So
overall, mediation's cheaper, it's quicker, the clients are in control of the process. What's not to like?
It's definitely worth trying, and the great thing at the moment is the government are offering a £500 voucher in any cases where there are children towards the cost of mediation, as long as you've had an initial meeting to establish the background and to check that there are no issues that would mean mediation isn't appropriate. Having had that meeting, you can apply for the voucher, and I would say it's worth trying. What is there to lose? It's a small fee up front for the MIAM appointment, then have a first session, and if it's not for you, no problem. You can then go to court, but why not try it and save your family thousands of pounds, not just of cost, but also emotional cost in terms of the uncertainty and delay of going to court.
Thank you.